Assembly Bill 1496 by Assemblymember Thurman, enacting to greenhouse gases.
Senator Wieckowski.
Mr. President, this is a proactive measure that will require the Air Resource Board to monitor and measure high-emission methane hotspots in order to protect air quality, public health, and reduce global warming. It is of critical concern to many of our constituents who routinely have air health alerts due to flaring at a local refinery, which is a source of methane emissions. I urge an aye vote.
Thank you, Senator Wieckowski. Members, debate or discussion? Seeing none, Secretary, please call the roll.
Allen. Aye. Anderson. No. Bates. No. Bell. Aye. Berryhill. No. Block. Aye. Cannella. No. De Leon. Fuller. Gaines. No. Gaggiani. Glazer. Hall. Aye. Hancock. Aye. Hernandez. Aye. Hertzberg. Aye. Hill. Aye. Hueso. Aye. Huff. No. Jackson. Aye. Lara. Aye. Leno. Aye. Leyva. Aye. Liu. Aye. McGuire. Aye. Mendoza. Aye. Mitchell. Aye. Monning. Aye. Morlock. No. Morrell. No. Wynn. No. Nielsen. No. Pan. Aye. Pavley. Aye. Roth. Aye. Runner. No. Stone. No. Vidak. No. Wieckowski. Aye. Wolk. Wolk, aye.
Secretary, please call the absent members.
De Leon. Fuller. De Leon, aye. Galgiani. Glazer. Aye.
Ayes 25, noes 13, measure passes. Members, without objection, we're going to move to file item 36. Senator Leno. Secretary, please read.
Senate Bill 178 by Senator Leno, enacting to privacy.
Senator Leno.
Could you find it? Okay, you went to that. All right. Yep. Thank you, Mr. President. Colleagues, this bill, California Electronic Communication Privacy Act, is back on concurrence. The Assembly amendments, taken at the request of state law enforcement organizations, deals with their concerns so that we can strike just the right balance between privacy and the ability for law enforcement to do its job. I would end my presentation there and just ask for your concurrence on Assembly amendments, but I'm going to have to take a few more minutes because there has been a misinformation campaign to try and derail this bill at the very last minute. The bill is joint authored by my colleague, Senator Anderson. We have among our co-authors is Senator Nielsen and Senator Gaines and a host of others. Nonetheless, I need to clear the air, literally and figuratively, to make sure everyone understands that these oppositional voices are not based in truth or fact. The bill, just to remind you, passed off this floor initially before we took the amendments to deal with the opposition of law enforcement, who are now neutral, State Sheriff's Association, State Police Chiefs Association, and the State District Attorneys Association, 39-0. So the bill still has, of course, the strong support of TechNet and the Internet Association, Google and Apple and Facebook and Twitter and the California Chamber of Commerce. The amendments, there are about 8 of them. I should spare you most of the details, but I just want to undercut some of the misinformation campaign. The amendments, again, which remove the Law Enforcement Association's opposition, clarify that undercover operations and monitoring of public peer-to-peer networks do not require a warrant. Also clarifies that law enforcement may retain and share information related to child pornography as part of a multi-agency database, like the Internet Crimes Against Children Task Force database. It creates an even clearer mechanism to delay constitutional notice in emergencies or when it would otherwise undermine an investigation. Traditionally, the person who is going to be served with the warrant has to be notified. But if there's risk to the investigation, that can be delayed 90 days, and that 90 days can be extended indefinitely. The allowance for wiretaps, keep in mind, is only 30 days. So as a result of our taking these amendments, in their neutrality letter, the California Police Chiefs Association said the following: SB 178 strengthens community relations and increases transparency without impeding law enforcement's ability to serve the needs of their communities. The District Attorneys Association, in their neutrality letter, said, we're pleased to remove our opposition and we're very much appreciative of your willingness to work with us on addressing our concerns. The State Sheriff's Association said virtually the same. And then just to put a final point on it, there are some national organizations which exist for the purpose of protecting children on the internet. Larry Magid, who's a member of the board of directors of the National Center for Missing and Exploited Children and CEO of ConnectSafely.org, founder of Safe Kids, and author of the first internet safety booklet, Child Safety on the Information Highway, says in support of the bill that this CalECPA protects privacy and children. SB 178 has the necessary provisions to assure that law enforcement can vigorously protect children and access the necessary information to investigate crime while at the same time extending basic constitutional protections to our digital information. So again, we're striking an appropriate balance between our Fourth Amendment privacy rights, and just to remind you, the bill in chief requires that law enforcement need a warrant before accessing your internet mailbox, your email box, just like they need a warrant to go into your snail mailbox, that they'll need a warrant before they can access your geolocation through your cell carrier provider, just as they need a warrant before they can put a GPS device on your automobile. And additionally, they'll need a warrant upon incident of arrest to go through your smartphone, just as they currently need a warrant to go through your laptop or your desktop or your filing cabinets or your office drawers. Basic 21st century protections for our digital information, bringing our statutes into the present day, accounting for the significant changes and abilities of our technology revolution. So I appreciate your taking all this in. I know it's a lot of information, but when an misinformation campaign takes place, it's our responsibility to slap it down and to substantiate that it is in fact not true. I ask for your concurrence on Assembly amendments.
Thank you, Senator Leno. Senator Stone?
Thank you, Mr. President. And I know that there's been a lot of great time that's been spent on this on both sides of the aisle. And while the proponents will claim that a number of law enforcement groups have removed their prior opposition to the bill, it must be noted that those groups removed their opposition before it became clear that SB 178 could negatively impact internet crimes against children task forces throughout the state. as of today, the following law enforcement organizations remain actively opposed to the bill, and it's unfortunate that their opposition would be considered to be a lack of truth or because of a lack of facts. That includes the Los Angeles Police Protective League, the Los Angeles Professional Peace Officers Association, the Association for Los Angeles Deputy Sheriffs, the California Fraternal Order of Police, the Long Beach Police Officers Association, the Association of Los Angeles Deputy District Attorneys, the Riverside Sheriff's Association, the Sacramento County Deputy Sheriff's Association, and one of the largest employer public safety groups in the state of California, the CCPOA. So, my friends, why would many of these public safety agencies that we have a lot of respect for be concerned about this bill? I've dedicated a lot of my life in public service to ensuring that sexual predators, some of the worst criminals in society, are held accountable. In Riverside County, I started the SPIDER program, Sexual Predator Internet Decoy Enforcement Program, which allowed decoys to work to attract sexual predators online. And as a result of this successful program, over 300 sexual predators from Buffalo, New York to Calexico were put behind bars. These organizations say that this bill will greatly diminish law enforcement's ability to conduct online undercover investigations and gather evidence. It mandates that a sexual predator can be notified, doesn't say shall not be notified, that a search warrant is being served on his electronic devices concurrent with the search warrant service. This bill could lead to a potential predator destroying files of child pornography. The bill also only provides one exemption related to child porn. That exemption reads as follows: if a government entity, law enforcement agency, receives electronic communication information voluntarily provided, it shall destroy that information within 90 days unless the law enforcement agency reasonably believes that the information relates to child pornography and the information is retained as a part of a multi-agency database used in the investigation of child pornography and related crimes. That's it. The exemption applies only to information that is voluntarily provided. The exemption only states that law enforcement doesn't have to destroy voluntarily provided evidence within 90 days. The exemption does nothing to protect traditional search warrant requirements utilized by law enforcement officials in child internet sex crime investigations. The single, remarkably weak exemption will do little to further law enforcement's goals of tracking down internet child sexual predators. And again, that's why so many law enforcement organizations are opposing the bill. A few issues that I would like to take into consideration, if you go to page 5 of SB 178, number 4, pursuant to subpoena issued pursuant to existing state law, provided that the information is not sought for the purpose of investigating or prosecuting a criminal offense. I find that very confusing. Also, it's troubling that if a remedy in the bill that states that if a portion of this section is violated, even when a legal warrant is issued and the remedy is a suppression of all the found evidence that may be required to prosecute an alleged child sexual predator. Again, I've heard from these respectable law enforcement agencies that I think just sends up a red flag that maybe we need to craft more deliberation here and ensure that while we all want to protect our privacy with our computers and our PDAs, the last thing we want to do, as we often do in the state of California, is fix the unintended consequences of bills And I want to ensure before I vote for this bill that there's not an unintended consequence that is going to protect sexual predators from being caught by law enforcement agencies. I would firmly request, if the author would be so kind, is to delay this until tomorrow so that I can consult with these law enforcement agencies to make sure that we're clear on what the bill does and what the bill doesn't do, so that we can ensure that we're protecting our children from the most heinous of criminals in society. Thank you for your consideration.
Thank you, Senator Stone. Senator Anderson?
We represent a large state with a lot of different interests. And while in one county, one sheriff's group is opposed, in San Diego, the Police Officers Association said, quote, SB 178 strengthens community relationships and increases transparency without impeding on law enforcement's ability to serve the needs of their communities. We believe this bill is the best interest of all citizens of California. For this reason, we are proud in support of this measure. You know what? We can have differences of opinion. I think what this really boils down to, nobody on this floor is in support of pedophilia. Absolutely not. We want to prosecute people to the full extent of the law. I think that we're trying to hit the magic point, the fulcrum that balances pursuing criminals and while preserving constitutional rights as set forth by the Fourth Amendment in the Constitution. So when we're looking at this, if you really wanted to take it to the extreme, we should all house law enforcement in a garage so they could keep a 24-hour watch on us to ensure that we've done nothing wrong. But that wouldn't be a free society. On the flip side, we could say, well, they can't search anything. But that's not what we're saying here. What we're saying is these new cell phones, they're not phones, they're handheld computers. And because they're handheld computers, they should be under the same rules and obligations as if you were coming into my house to seize my home computer. That's all it says. The Supreme Court has ruled on this. This is a delicate balance. I get it. Maybe some criminals may get loose, but 38 million Californians will live in liberty. And I think that liberty always comes at a cost. We're not promoting pedophilia, but I think that's why when you look back, we have these letters of neutrality coming from these outstanding organizations. I don't think the DAs, the California District Attorneys Association, I don't think that is a schlock group that doesn't understand the law. I think that they're bright people and they've looked at this very closely and they like to put pedophiles in jail. I think when you talk about the California State Sheriff's Association, I don't think any sheriff hasn't spent a lot of time in law enforcement working up through the ranks, seeing different parts of crime and how it interacts. These are smart people who apply the law, who prosecute the criminals. The California police chiefs, again, this is not a group that rolls over for crime. So, members, I get it. If your homegrown sheriff is against it and you want to be on board with them, absolutely you should. You should vote your conscience. But on the flip side, if you want to strike a balance so that people don't barge into your house and take your home computer without falling within the Fourth Amendment, if they don't pull you over because of a broken taillight and ask to go into your handheld computer, I'd urge an aye vote.
Thank you, Senator Anderson. Further debate or discussion? Seeing none, Senator Leno, you may close.
Thank you, Mr. President. Colleagues, the suggestion that the three major state law enforcement organizations did not fully understand the bill or there has been some change to the bill since they removed their opposition is completely false. One other provision of the bill, which has always been in it, allows for exigent circumstances that if, in an investigation, there is any risk to loss of life or injury of life or loss or risk of any evidence or information in the case, the warrant requirement is waived. unilaterally by the law enforcement officer, him or herself. They don't need to get concurrence with a court. They can say information is at risk of being lost. They can say a child's life is in danger, warrant requirement waived. I ask for your concurrence on Assembly amendments.
Thank you, Senator Leno. Secretary, please call the roll.
Allen. I. Anderson. I. Bates. Bell. I. Berryhill. I. Block. I. Cannella. I. DeLeon. Fuller. Gaines.
Aye.
I. Galgiani. No. Glazer. Hall. Hancock. I. Hernandez. I. Hertzberg. I. Hill. I. Wesso. I. Huff. I. Jackson. I. Latta. Leno. I. Leva. I. Liu. I. McGuire. I. Mendoza. Mitchell. I. Monning. I. Morlock. I. Morrell. Wynn. No. Nilsson. I. Pan. I. Pavley. I. Roth. I. Runner. Stone. No. Vidak. No. Wykowski. I. Wolk. Wolk, aye.
Secretary, call the absent members.
Bates. I. DeLeon. Fuller. Glazer. I. Hall. Latta. I. Mendoza. I. Morrell. I. Runner.
Ayes 32, noes 4. Assembly amendments are concurred in. Members, we're now going to move to motions and resolutions. Members, there's a resolution at the desk requesting to suspend Joint Rule 61A 13 to allow Assembly Bill 798 to be amended on the floor after the deadline. This request has been approved by the Rules Committee. Any objection to unanimous consent? Secretary, please call the roll. Secretary, call the roll.
Allen. Anderson. No. Bates. Bell. I. Berryhill. Block. I. Cannella. DeLeon. Fuller. No. Gaines. No. Galgiani. Glazer. Hall. I. Hancock. Hernandez. I. Hertzberg. I. Hill. I. Wesso. I. Huff. Jackson. I. Latta. I. Leno. I. Leva. I. Liu. I. McGuire. I. Mendoza. I. Mitchell. I. Monning. I. Morlock. No. Morrell. Wynn. Nilsson. Pan. I. Pavley. I. Roth. I. Runner. Stone. No. Vidak. Wykowski. I. Wolk. Wolk, aye. Galgiani, aye.
Secretary, call the absent members.
Allen. I. Bates. Nilsson, no. Berryhill. Cannella. DeLeon. Glazer. I. Hancock. I. Huff. Morrell. Wynn. Runner. Vidak.
Secretary, call the absent members.
Bates. Berryhill. Cannella. DeLeon. Huff. Morrell. Wynn. Runner. Vidak.
Move the call. Can I go to the restroom? Or do we have too many things?
Okay, hold on. I think
Should I have Senator McGuire?